I'm very happy to be invited to this to present this talk to you today. I will I will share my screen first with you. I hope everyone can see it. So my name is Stefan Gompel. When I was invited to this talk by Christina Angelopoulos, she asked me what type of research are you engaged in, and the thing is that I've been engaged in a topic for already quite some time, which was copyright formalities. But in the new age of copyright data, that gets a new life in a way. And I've been doing a few studies for WIPO on voluntary copyright registration, and I recently wrote a paper together with Martin Zentfleben and others, which basically touches upon copyright data, but essentially from the perspective of formality. So I thought that would be a good angle to present as a topic for you today. But just let me introduce first why copyright data is so important. And it might be a bit self-evident for those who know it, but because it could be a broad audience, I thought I would just start off anyway from the beginning. And that just, of course, is the digital environment. There's constant use and reuse in the digital era. We find videos online, we find photos online, and we want to use it for PowerPoint presentations. We want to use it for our blogs or websites, or we want to basically share it with others on social media. So constantly in our daily lives, copyright relevant uses take place. But not just in our daily lives, copyright is also reused professionally in quite some instances. I just took two examples. Documentary filmmakers, of course, they incorporate existing materials in their documentary films. So that could be old footage, but it can also be recent work. They want to put music under their films, etc. But there's quite some reuse of materials. And the same is with the whole digitization project, the digital libraries, digital archives, etc. The whole digitization process was a huge copyright operation, so to say. And then, of course, there is the large-scale commercial reuse and use of information. And I just take the example of music. Of course, we have lots of platforms that play music, the Apple Music, the Deezer, the SoundCloud, the Spotifys, but also in more contemporary artificial intelligence systems like music recognition software, Shazam, and even robot computer software creating new types of music on the basis of older existing music. And they need to be fed with lots of copyright data, copyright information, basically copyrighted works in their computer system in order to produce new music. For example, the Deep Bach system does that on the basis of the old music of Bach, can create new types of music that resemble Bach. So anyway, there's lots of reuse of copyright materials in the digital era. And in order to use copyrighted materials, you need data, you need information, because what is, of course, the case is use typically requires permission. When you engage in copyrighted materials, you can make a reproduction or you can communicate it to the public. And these are copyright restricted acts. They are exclusive rights that belong to the copyright holder. And that's only, so that requires the consent of copyright holders, except in two circumstances: when you can rely on an exception or limitation, or when the work resides in the public domain, when the copyright term has expired and you can freely use it, or when there's a free license to use particular types of materials that you can find in specific databases on royalty-free photos or other materials. So, and if you need to get permission from right holders, you, as a user, of course, need access to relevant copyright data. You need to know what type of object you're dealing with, and I will give an example later. You think as materials as one object, but there can be multiple layers of rights involved. I will give an explanation of that in a minute. You need to know who the author is of the objects that you are reusing. You need to give attribution to them, but also the term calculation, copyright expires 70 years after that of the author, also needs users' knowledge of who the author of the work is. And finally, of course, you need to know who are the current right holders, including contact details if you want to ask permission to use the work. And then As a side note, copyright data might also be relevant for users that are under an obligation to report use. For example, music services that have a collective license with collecting societies for music might get a blanket license that allows them to use all types of materials. But usually they are under an obligation to report back to the collecting society what type of music they used, so that the collecting society can distribute the money that they got from this type of use to the relevant right holders. So also their copyright data may be relevant. Just this example of one object, not meaning you have to ask permission of one person, is for example, recorded music. So that's a data challenge. Recorded music actually consists of multiple layers of protection. So there's copyright on the musical composition that you hear. That belongs to the composer or the right holders of the composer. The copyright on the musical lyrics. So the lyrics that you hear, the lyricist, it's the author, but it can also be transferred to others. There are related rights on the recorded performers. That belongs to the performing artists. And finally, there are related rights on the sound recording, which belong to the phonogram producer. So there's one single object, but multiple layers of rights. And if you need to ask permission, you need to ask permission on each and every layer of these rights. So you also need to have data for each type of right that you want to reuse. So that's one challenge for the reuse of copyright and the data involved in that. Another challenge is that copyright and related rights can be transferred to others. And that can be contractually for exploitation purposes. So as an author, you created a work, but you want the publisher to publish it and distribute it. You usually transfer your rights to the publisher in order for the publisher to make the exploitation. That means that the right originates in the author, but in the end goes to someone else. The right also passes upon the death of the author or the right holder who owns the right. So it automatically transfers to others after the death. And of course, there's when copyright resides in companies, after a merger or acquisition, copyright goes to a succeeding company who takes over and then also takes over the rights. So copyright moves. It exists. It starts with the work. The creator owns it, but it often passes on to others. And the thing is that rights that can be done in whole, copyright can be assigned as a whole to a third party, but it can also be in part. So copyright may be split by a type of right. You only give a publisher certain types of rights and others remain with you. You might assign some rights to a collecting society. It means that copyright is split in the end by type of right, by type of use, sometimes by distribution channel. It can be split geographically, so you transfer your rights for a certain territory to one publisher and for another territory to another publisher. So in the end, copyright splits and may be owned by different persons or entities depending on the transfers that have been made. And that makes it difficult if you don't know which transfers have been done in the past. Then just to complete the picture, while the exploitation rights can move, moral rights always retain with the author, so the author is always a relevant party, even after the transfer, because the author always retains the moral rights. The problem when we talk about all these things, because this might be self-evident for those who are involved in copyright, but the thing is that in copyright, there are no universal database or registries that you can easily go to find relevant data about copyright. And in that respect, copyright and related rights are different than, for example, trademarks or patents or designs. There are, of course, a few databases online where you can, for example, find royalty-free images, but that's only a fraction of the works that exist out there, and it's mostly recent materials. Sometimes it can contain older stock photos as well, but it's limited by themselves. It does not cover even it only covers a fraction of the works. There is also much data available with collecting societies, with collective rights management organizations. But these are private parties that offer little transparency. You can go there to get a license, but they will not have an open catalog with all the information about which titles they control, who are the right holders, what is the contact information. That's all in their private hands, and they want to license the works to you, but they don't want to give up this information. It's private information that is held by these societies, and they're often black boxes in that respect. Also, a thing is that not all works contain relevant copyright information. Think about photos and videos, etc., where there's not even a mentioning of the copyright of the author, let alone of the copyright owner who controls the rights. There are, of course, in the digital environment, sometimes licensing conditions attached to works, Creative Commons licenses, open access licenses, and they allow you, under certain conditions, free use of those works if you stick to the licensing conditions. But here again, this also only covers a fraction of works, and mostly are recent materials. You don't see Creative Commons license attached to older works. They are all, the Creative Commons system was introduced in the early, in the beginning of the millennium, but didn't exist before. So that already explains, given the full length of copyright, that only a fraction of the works is covered by Creative Commons or other open access types of licenses. So what is then the background of the copyright data shortage, as I will call it? Well, that's the international prohibition of formalities. Article 5.2 of the Berne Convention says that the enjoyment and the exercise of copyright shall not be subject to any formality. And this rule is also incorporated by reference in the TRIPS agreement and in the WIPO Copyright Treaty. So basically all big copyright treaties prohibit the enjoyment and the exercise of copyright to be subject to formalities. And that explains why there are no registries or databases, in contrast to patents, designs, and trademarks, for which registration typically is even constitutive of the right. It's not in all countries. In the US, for example, trademarks exist upon first use. But in most countries, in order to get a patent, design, and trademark, you need to first register it in order to get the protection. And that's not the thing in copyright. Copyright exists automatically with creation. You don't need to do a formal act. You don't need to register it in a database. You don't need to attach a copyright notice to a work. You get it upon the creation, and that's it. No formal acts involved. It also means that there are no formal acts that involve data that is used publicly. And that's the subject of my PhD thesis that I wrote in 2011. I used the book here. If you Google it, you can also find it in a PDF. It's available through the database of the university, so you can look into it if you're interested. But when I was doing this, there was not, of course, there was the big data, but the whole discussion about artificial intelligence, for example, in 2011 was not very lively, and it's something that is really is booming in the last 5 years, so to say. And there, the call for data and information, etc., came along, and that's all of a sudden a big thing again. So what I want to concentrate on for the last 15 minutes are, of course, possible ways to enhance data, copyright data, measures that we can introduce to allow broader access to data. So one thing is to promote basically metadata attached to digital content. If content would be, if metadata, machine readable data, or easily accessible data would be attached to digital content, it has the benefit of information automatically traveling with the work. And when it travels, and as a user, you could obtain this information and find out who controls the rights, etc. That would be beneficial if you want to ask permission. The difficulty is, of course, that if you attach information, that might get outdated over time. So if metadata is static information that is attached to a work, it might work for the first years, but after some time, maybe the rights get transferred again, maybe the right holder passes away and goes to the ears, etc. That makes it more complicated. There are, of course, also ways to try to tackle that. There would be a link to a database with more up-to-date information that would be that would cure that difficulty of the outdated information. But first of all, you need to have this information tagged, and then it should then require a link to a database with up-to-date information. That should then also exist. So how do we get databases with up-to-date information? That's maybe another measure to think about as policymaker, as legislator, is to stimulate the recordation of transfers of rights. What do we mean with that? A recordation of transfers of rights. If transfers and assignments of copyright would be recorded in a public register, that would ease the information. It would enable users to trace a chain of title. It originated with the author, how did it continue, and who owns the copyright at this point. So recordation is an important thing. If the copyright contracts would be, or at least the core of the copyright contract, who particular rights are assigned to, would be publicly available in a database, that would ease transactions significantly. A third thing that I will discuss with you tonight is to encourage voluntary copyright registration. Voluntary copyright registration establishes a public record of copyrighted works, and if as a user you could go there and obtain information of who owns what type of materials and what type of work, that would be beneficial for users. The thing is, of course, that since registration is voluntary, cannot establish a complete record. But there are incentives that you could introduce into the system that basically stimulates right holders to register their information and to get an as complete record as possible. And this is something that that we touched upon in the context of the Article 17 of the Copyright in the Digital Single Market discussion in the paper that we did with Martin Zandvleven and others, which I will briefly discuss in the very end. So with these 3 points, I will go to them one by one. So first of all, the metadata tagging of digital content. There are essentially 2 problems. First problem is that there is no consistent and uniform use of metadata at the moment. Everyone can attach whatever metadata to their works in whatever form they want. The definition, Article 12 of the WIPO Copyright Treaty, protects metadata against removal and tagging and tampering. So sorry, but this definition of what is rights management information, as it's called in the WIPO Copyright Treaty, is very broad, and it protects rights management information regardless of the combination of information it includes. So it's very broad and open-ended. It's not a strict definition. So to encourage the use of metadata and to improve license of metadata tagged works, one idea is to subject the protection of rights management information to the requirement to provide a set of basic copyright information. So a kind of a uniform metadata standard that at least shows the type of work, who the right holder is, etc. And if that's done consistently and uniformly, that could very much ease the information problem related to the metadata. And ideally, that would be an international standard, so a unique identifier that is used throughout the world, so that it's as standardized as possible. And it would be compatible, arguably, with the WIPO Copyright Treaty to mandate this by law, saying this particular types of metadata should be attached in order to get the protection of Article 12 of the WIPO Copyright Treaty. That has, for example, been argued by Rickardson and Ginsburg in their big book on the Berne Convention and beyond. Another idea is to require right holders who want to rely on the protection of Article 12 of the WIPO Copyright Treaty to deposit the rights management information in the public register. That's what I argued in my book on formalities, that this is compliant with international prohibition on formalities, because this international prohibition on formalities of Article 5.2 does affect copyright, but is not applicable to the ancillary protection of rights management information in Article 12 of the WIPO Copyright Treaty, or, for example, the protection of digital rights management systems in Article 11 of the WIPO Copyright Treaty. So it's compliant with international prohibition on formalities as long as it does not affect the protection of copyright. So if it does not affect the copyright, if you are required to deposit rights management information, but you maintain the information, it's only you maintain the copyright in its full form. It only affects the protection of the metadata that you attach to the work in the context of Article 12. That should be compliant with the prohibition on formalities. So that's one measure to consider. The second measure is the recordation of transfers of rights. I already said if transfers or assignments of rights are registered in a public repository, that would very much ease the licensing problems, the data problems, because you can trace the chain of title. In 2021, I did a big survey for WIPO, where we sent a questionnaire to 193 WIPO member states, of which 106 countries responded. And it dealt with three things: voluntary registration of copyright, recordation of transfers of rights, and legal deposit. But on the part of the recordation of transfers of rights, 45 out of the 106 countries indicated that they have in place a system of recordation. In 44 of those countries, the system of recordation was linked to the voluntary registration system. But there was also one country that indicated that it does not have a voluntary registration system, but it did have a recordation system for the transfers of rights in audiovisual works. That's in France. So this shows that even if you don't have a voluntary registration system, it would still work to have a recordation system. But it might be difficult because in the end, you also need to understand to what type of work it relates. And if it's very specific for audiovisual works, that can still be done. You could have identifiers on audiovisual works and still make the system work. But it's more difficult to do this for all types of copyrighted materials if you don't have also a voluntary registration system. But it shows that it could work. The survey showed that the national systems on recordation vary significantly, both in terms of what they record. Some record full contracts, which are then not made public to the world, because otherwise everyone could understand what type of rights have been assigned for which type of fees, etc. So there are recordation systems that are relatively closed, but record everything. Other systems merely record statements of who owns what after the transfer, and that are usually publicly available information. So the latter, when things become publicly available, that can ease transactions, copyright transactions, copyright data problems. But if it's closed, it does not. So if you want to read more on this, you can search the WIPO survey, which contains quite some detailed information on that. So as I said, recordation can eliminate the data shortage caused by the transferability of rights by showing who the current owners are of the particular types of rights. It's important to understand that recordation can also be made mandatory. So you have voluntary recordation systems that basically allow you to record documents or statements on assignments. But in some countries, recordation is mandatory. And what it means is that it's not just merely a declaration of the assignments made, but the law then requires recordation in order for the contract to be effective and enforceable against third parties. That's, for example, the case in Argentina. And also such a mandatory system of recordation, because if you can't have your transfer being effective against third parties, no publisher is interested in a deal like that. So that will automatically stimulate them to record the transfer. Then the question is this compliant with the international prohibition of formalities? The answer there is yes, this is also compliant with the international prohibition on formalities, as long as it leaves the enjoyment and exercise of copyright as such unaffected. And if it's only means that your transfer, the contract cannot be made effective against third parties, that still means that the initial owner, the initial holder who makes the transfer to the other party, can still enjoy the protection, the full protection of copyright, and enforce it against third parties. So that's also not that's also in agreement with the prohibition on formality. So that's another thing, another system that you can think about. The third thing is, of course, voluntary corporate registration. If registration is voluntary, it would not be prohibited by the Berne Convention, because voluntary registration, everyone can do voluntary acts and also voluntarily register their works. The same WIPO survey that I already mentioned of 2021 shows that voluntary registration of copyright is quite common. 67 out of the 106 countries that responded to the survey have in place a system of copyright registration. These systems are mostly nationally oriented. They have strong domestic characteristics. They exist on the basis of the laws of the country, and also the system has been devised according to the preferences of the country. So there are huge differences between the systems in place. What I also noticed that not all registries are fit for the digital era. Not all allow digital registration. Not even all registries are available in a digital format. Quite some are still not. And that also can be explained historically. Many of these copyright registries, which exist, for example, in the US, Latin America, and in some African countries, and quite some Asian countries, including China, some of these institutions are very old. Like the US Copyright Office has been established at the end of the 19th century, and many of the copyright offices in Latin America have also been established around that time or a bit later in the early 20th century. But they're old, and they grew up basically in the analog world, and they first existed as analog registries, and they have to accommodate, and they are accommodating to the digital environment, but that goes slowly. It's certainly not there, and it's certainly not fit for full digital use and digital services. The third thing that I want to mention in this respect is that there's little international cooperation between the national registries. That's due to quite some reasons. There is a lack of standardization already at the level of the law. So since copyright is territorial, it's the National Copyright Act that defines what are the protected subject matter. And although there is some uniformity around the world, there are also national differences. There are also domestic differences in terms of what types of protection, what types of works are protected and what types are not. Other than that, other than the legal differences, there's also a lack of standardization in identifiers, object identifiers, and also in the metadata, the information that they want to have included in the registries. So if you want to make them interoperable, if you want to create a system of interoperable registries based on what exists there, there's quite some work to do, and it requires quite some international cooperation. Yeah, that's still a far future as far as I can see that at this point. But regardless of that, voluntary registration is an interesting system because because of the data that it generates. But as I said, because it's voluntary, the system somehow needs legal incentives. You can call them carrots or sticks if you want, to encourage right holders to register. And the idea there is to give right holders certain benefits that they would otherwise not enjoy without registration of their rights. So to give an example of what can be such incentives, and then I will zoom on to the last part, the incentives in the Article 17 of the Copyright and Digital Single Market Directive. Some examples in the US copyright law is that registration constitutes proof of the validity of copyright and the facts registered. Of course, that's prima facie proof, so that can be rebutted, but it gives some strong indication. So for right holders, that can be very beneficial, that they have some piece of paper showing that they own the rights in certain types of objects. In the US, it's also important that in order to get statutory damages in trial or to recover attorney's fees in trial, you need to have registered, because otherwise there will be no award of statutory damages or attorney's fees. So you have to fall back on the normal damages, which are more difficult to establish. And statutory damages are kind of high. They are up to $150,000 in the US. So that's quite significant. So that's another benefit of registration. And then for US works, registration is also a condition to sue for copyright infringement in a federal court. But that's only for US works, because otherwise that would be in disagreement with the Berne Convention, because that would relate to subjecting the enjoyment and especially the exercise of rights, the enforcement of rights, to a formality, and you can't do that internationally because of the Berne prohibition on formalities. So this last part is only for US. So then, as I already said, we also developed a new type of incentive, or an idea to create incentive in the European system to generate more data there. And this idea came up essentially when drafting a paper with Martin Zenflebe and others, Thomas Margoni, Daniel Antal, Balazs Bordeaux. You see them mentioned here. Martin Kretschmer participated, Christian Hanke. So we had a whole a group of scholars with which we were writing this paper on copyright data improvement. And in September we were having actually a dinner at the Hugenholz conference, and I was sitting at the table with Martin Zenflebe, and he said, we somehow need to kind of find a way to really put a legal requirement there. And can't we think about something like formalities related? Can't we make, for example, the whole system around notice and takedown subject to the requirement to also deposit information in a public repository? So what we did afterwards is, and I really liked Martin Zenflebe's suggestion in this respect. I think that he was brilliant to think about Article 17 discussion to also give it a positive tune of generating data. We created in this paper, which is available on SSRN, and which will hopefully be published in GPTech. We created this proposal to require right holders in the context of the notice and takedown procedure under Article 17.4 to require them to submit copyright data in a public register before they can benefit from this notice and takedown procedure. And the idea here is really that if right holders are willing to voluntarily submit data anyway to platforms, to require those platforms to take down content, why not require the same right holders to also deposit this copyright data in a publicly accessible register? So to get the copyright data flow going and to improve copyright data to the benefit of all. So some considerations on the pros and cons, and this is my last slide, so we can have some discussion on this afterwards. Well, first of all, this is also not a prohibited formality, because copyright can still be enforced outside the notice and takedown and notice and stay down procedure of Article 17.4. That's one thing. So copyright holders can still enforce it, but not through the notice and takedown system, notice stay down procedure of Article 17. But in a way, it's still possible to enforce rights. We thought of, if there would be a public repository, what's the benefit there and who should do it? So the idea is to establish this at EU IPO, which already does, of course, the registration of trademarks, of designs, and which also does some types of registration of copyright in the context of orphan works and in the context of out-of-commerce works. So basically, they are equipped to handle bigger registration questions. So they could establish a public repository in the context of Article 17 as well. And the big benefit of having a public repository over not having a public repository is that it ensures that the relevant copyright data is not merely held by private entities. If there's lots of copyright data submitted to large online platforms like YouTube and Facebook, who are already controlling quite some data, it also makes them, in the end, gatekeepers, important gatekeepers of relevant copyright data in Europe. And the brilliant thing about Article 17 is that it kind of moved from a voluntary system, because the notice and takedown procedure, of course, already exists long before, but it was implicitly based on the e-commerce directive. But the e-commerce directive does not contain an explicit notice and takedown or notice and stay down procedure. But since it is now explicitly stated in the law, you can also attach a requirement there to have this data submitted to a public repository. So that's the benefit of having it now laid down in a real law. And it could also work it could be what could add to this idea of having data be deposited in the public repository, especially when it concerns the fingerprints and the data required to make nodes and takedown and nodes and stay down actions, is that if the law would also require a uniform standard to be applied by all platforms, it could also lead to some standardization that would be to the benefit of right holders. Now, right holders have to provide fingerprints maybe in different types of forms to different types of platforms. If all platforms would have to accept one standard that would be publicly available, that could also ease the enforcement of right holders in the online environment. There are so the way I explain it is, of course, like hallelujah, we found a solution. There are also some cons, of course. The data to be provided for notice and takedown and notice and stay down actions is not necessarily the data that would be required for relevant use for all relevant use for copyright. So notice and takedown and notice and stay down in the context of Article 17 is first of all limited to the communication to the public right. So you need to have the right holder of the communication to the public right who could then submit an action for notice and takedown, notice and stay down. But it does not necessarily cover the entire right. So that's one thing. Second is the data as such. Notice and takedown, notice and stay down requires fingerprints. Fingerprints as such are not necessarily relevant data for copyright use, but still, even depositing fingerprints to YouTube, etc., right holders also have to identify somehow the content that they want to protect. So some relevant identifying information can be expected to be required at least. And on top of that, a public repository could also, of course, open up more data submission through on a voluntary basis. So it should not necessarily be limited to the confined data that is needed for the notice and takedown, notice and stay down procedure. And then a question, of course, what would this do with the balance between right holders, platforms, and users? That's an important question. I think it should be prevented that this would limit the liability of platforms too much. So if this would create too many hurdles for right holders who already have to take action in order to have their content be removed from the platform, it would if it would create another big obstacle, then this might mean that there will be less likely that the platform gets liable. At the same time, I do think that if right holders want to follow the path anyway of making a notice and takedown, a notice and stay down request, they would have to provide this information anyway. So if this could be done through a public repository rather than directly with the platforms, that would it would not create an additional hurdle by definition. At the same time, as I said, for right holders, it could have benefits if the metadata required would be standardized, so that it could provide one and the same type of metadata to a public platform that could be used for notice and takedown and notice and stay down requests for multiple platforms. And in the end, for users, it would not necessarily have to make too much difference. In fact, it could also be a small plus for users, because nowadays users have no clue at all what types of licenses the platforms have, what type of content they upload will stay, what type of content will be taken down, whereas a public repository could give some ideas about what type of content the right holders are very seriously about enforcing, and therefore also gives an idea about what type of content they can freely share on those platforms. So I think also for users in the end, there are some pluses about this system. And with this, I would like to open the floor. I'm a bit over time. That's usually the case when they say you can talk for 30 minutes, but in the end you talk for 45 almost. Sorry for that, Christine.
I think that's perfectly okay, Stef. Okay, so in that case, we can open up the floor for questions. I was going to ask a question myself, but I see that we already have a question in the Q&A. I should ask participants to do exactly what I see that my colleague Henning has done, which is that if they do have questions, to use the Q&A button at the bottom of the screen as opposed to the chat button, because that makes it easier for me to keep an eye on the questions being asked. So Steph, I think you can also see Henning's question, but I'll read it out. So Henning asks, if mandatory, if I understood correctly, formalities are applied to subsequent right holders rather than authors, does that not cause issues under Article 2.6 of the Berne Convention, which states the works mentioned in this article shall enjoy protection in all countries of the Union. This protection shall operate for the benefit of the author and his successors in title. The type of works covered under Article 2 of the Berne Convention, of course, include all relevant types of literary and artistic works. So would the obligation that such works enjoy protection not require protection in line with other Berne rules, including the prohibition of formalities?
And
so Stef, your
yes,
thoughts?
My question is immediately, in which type of context do you ask this for in the context of recordation? Because there you, or just in general?
So I don't think there's a way to give Henning the floor.
So if I understand it correctly, the question relates to Article 2.6. The works mentioned in this article shall enjoy protection in all countries of the Union. So that essentially says that the works covered in Article 2 is like this are part of the how's it called, the international acquis, the international body of the law. So all countries have to protect these types of works, and the protection shall operate for the benefit of the author and his successors in title. Yeah, I can imagine that if for example, recordation would become mandatory, you would say, okay, but then the successors in title cannot enjoy the benefits of this protection. At the same time, maybe if the full transfer has not been succeeded because you have not, for example, complied with a recordation requirement, then the question is whether you can legally speak of a successor in title. I would have to think a bit more about this. It's an interesting suggestion, but I don't think that it's necessarily an obstacle to a recordation system, to a mandatory recordation system, because the provision on formalities relates to all rights that are covered by the Berne Convention, plus the rights to which you have to give national treatment. But they would still enjoy protection for the author and subsequent right holders if they would comply with the conditions for the transfer. I mean, there might be other conditions to get a right transferred as well. For example, to do it in writing. That's just a legal requirement that you can also include.
So I don't know if that helps, Steph, but Henning has two subsequent sort of comments clarifying his question. So he says he meant the question in the context of systems requiring formalities for subsequent right holders, which I think you understood. And then he says, I thought you were arguing that mandatory formalities can be applied to publishers.
Yeah, the thing is that in the context of recordation, for example, yes, it can be applied to the subsequent right holders as well. All these systems of recordation basically apply to any type of transfer being made. So yes, it could be applied to publishers as well. Yeah.
Okay, I hope that answers the question, Henning. Yeah.
Okay. Yeah.
Were you going to say something, Steph?
No.
Wonderful. So Henning, if you have any follow-up questions, of course, feel free to use the Q&A. If anybody else has any other questions, of course, feel free to use the Q&A button. In the meantime, I have a question, Stef, which is about your suggestion with regard to Article 17. And I was wondering if you could elaborate a little bit on the intersection between that suggestion and the prohibition of formalities. So you said in the presentation that you don't foresee a clash because copyright would still be enforced outside of the notice and takedown and notice and stay down procedure, which makes sense, but it would not be able to be enforced vis-a-vis the platforms, right?
No.
So it would be a formality with regard specifically to the enjoyment of copyright and the enforcement of copyright as against OCSSPs, online content sharing service providers. So how would that interact with the prohibition on formalities? And in addition, just to follow up on that, how would this solution combat the problem of static data? I mean, obviously, right holders would have the option of updating the data, but they would only have an incentive to do so to the extent that they want to continue enforcing their copyright on OCSSPs. And it may be that after a certain point, this isn't in their interests. Maybe the work falls out of use. They don't see the point in putting in this extra work. So I was wondering if you could give your thoughts on those two issues.
Yeah, just to start with the latter, you're absolutely right. It's a kind of a registration at a given point in time, and it remains static, the whole information. That's essentially the same with voluntary registration. It's voluntary registration at a certain point of time, and the same as with metadata that is attached to a work. That's metadata that is relevant at a certain point of time. So all these three types of mechanisms are relatively well, they provide data, but they provide data that might get outdated soon. And the only way to tackle that is recordation, in a way. Yeah, that gives an idea about which rights have been transferred later on. So for the data shortage, I think that recordation is the most important means, because it gives ideas about where rights belong. So if you want to think about outdated information, that's the system that could cure that. So the static information, yes, that's a very good point. So without recordation, that's not covered. About the prohibition on formalities, yes, if registration in a public repository would be required by right holders in order to start a notice and takedown, notice and stay down procedure, the effect is that if they don't do this, they could only not enforce their rights through the platforms. But we do see that that's one of the ways that right holders easily choose to enforce their rights online. To go one-on-one after an individual right holder is less beneficial. So the thing is that the whole idea behind an incentive, so to say, is that it should provide like the right holder should be better off with this. But the price is to give up data in a public repository and not just in the private repository. So the idea is there, since they already do this in a private repository, namely to start a notice and takedown, they already do this massively, at least the larger companies that are very serious about enforcement. They already do this, and there you already see that, for example, the content ID system of YouTube, from a data perspective, is quite a successful system. It contains quite some data on copyright protected works, of course. And that data is completely owned now by a private entity. And the idea is that it would be beneficial for the public to have this data open for subsequent creators or whoever wants to get information about copyright use. That could be beneficial. And that's the idea behind it. And as far as the prohibition on formalities is concerned, that essentially says that you can't you can't introduce formalities or legal requirements to submit information in a repository if that would mean that you cannot enjoy your rights, but this system does not prevent the right holders to enjoy their rights. And it also does not, in effect, make the enforcement of rights impossible. It makes the enforcement through the notice and takedown through platforms. Yes, that would be impossible, but the rights would still be enforced. Just not through the notice and takedown. Just
okay.
The difficulty there is, what does this mean with the liability of the platform?
Right, exactly.
Because that's what I said. So it should not upset the balance in such a way that all of a sudden it would create insurmountable hurdles that right holders would not go through the notice and takedown system anymore because of they don't want to make certain types of data public, for example. And therefore, platforms can do whatever they want, just escaping liability under Article 17. That's not the idea. So there should be clear thinking about, would right holders be willing to submit particular types of data in a public repository as well? And so we also had a discussion within the team. This is not just my idea; it's an idea of course a research group. So we also discussed this with several of us, and so I had some concerns about, for example, collective rights management organizations. Will they be willing to submit large amounts of data to a public repository if they are very keen on keeping it private in their own hands? So the notice and takedown system could, of course, also be started with collecting societies that hold information.
Okay.
So that's my concern a bit.
Okay. So we're running out of time, or we're running a bit short on time, but in the meantime, we have one more question in the Q&A from Lionel Bentley.
Yeah,
and
it's also
he
a good point.
Yeah. Shall I read it out, or shall I assume that everybody has read it?
Yeah, it essentially touches upon a bit what I also said in the end. Lots of this, of course, the right holders that are very serious about enforcing their rights, they're usually also the ones who are easily approachable. So the big American studios, it's not very difficult to reach out to them to ask permission. If you get it, that's a different thing. But the thing is with the Article 17, since it applies to all types of works and all types of data, we're now getting into the situation that all of a sudden also collecting societies for images are very much engaged in the debate to get some licensing done through Article 17. And of course, for images, the copyright situation is not at all clear. And those collecting societies that hold copyright in images also do not establish public information on who owns rights in what. So it's for a user, it's still not easy to exactly understand what type of materials that those collecting societies hold and which types of because it's also in their strategic interest not to have a full open catalog of all types of images, all types of right holders that they represent. For collecting societies, often more beneficial to see what types of users there are, and then tell a certain user, you're also using the materials that I hold rights of, and you need a license with me, and then things are fine. Otherwise, we'll sue you. That happened, for example, with quite some archives in the Netherlands that got sued by a collecting society in the Netherlands because they were reproducing images of which the collecting society has rights, and they basically said, if you get a license, and then things will be fine. And there you see the black box effect. For many types of users, it's not at all easy to understand who owns what in what types of older materials, for example. And if they would be serious about enforcing their rights, they would have to deposit it. But that's the question, whether the cost of enforcing rights in images, even the notice and takedown system, outweighs the benefits of the notice and takedown. So that's the question, and depending on that answer, the system might generate information or not. That's how I see it.
Okay, so we have about 2 minutes to go. So maybe just very, very quickly, if I ask another question, which is, and I assume, well, the answer may very well be no, or we don't know. But is it clear, or do we have data on the extent to which the lack of copyright data is an actual problem in practice? As in, is it actually inhibiting people from using works? Or are people, for example, just going ahead with the use of whatever they want without permission, or without being excessively concerned about copyright? Is there a way to measure the damage that these solutions would be rectifying?
Yeah, that's a good question, Christina. I think that there's no data on this. It's also very difficult to establish data. I'm currently engaged in a project which deals with the reuse of copyright materials by documentary filmmakers and curators of cultural heritage. And there you see that the copyright issue, the difficulties of who owns rights in what, and the clearance culture that is especially dominant in documentary filmmaker, does, for some projects, make documentary filmmakers very uncertain about the situation of rights, and therefore they sometimes stop productions because they're just too uncertain. There are other ways to go around this that you might think about. More, what we are doing in this project is to define codes of best practices for audiovisual reuse, also looking, for example, at the quotation right. It's essentially also a bit based on the book that Lionel is released with Tanya Applin a couple of years ago. Quotation in the audiovisual context is, of course, permitted under the Berne Convention. It's also permitted according to the Dutch Act, the Dutch Copyright Act, for example. But in a way, we're not used to quoting audiovisual materials, and therefore no one does it, at least very few do it. And therefore we end up in a clearance culture, and then you come up with the copyright data shortage. And yes, then some projects are abandoned in the end because of the difficulties in clearing rights, whereas they might, in certain circumstances, also rely on fair dealing or quotation right in the Netherlands, or whatever exception is available. But there you do see there are examples. But how big the problem really is, in the end, there's lots of, especially in the online environment, there's lots of copyright that is not enforced, and the enforcement is really taking place on the platforms. But well, less individually, well, maybe with photographs on the websites, etc. Some organizations are pretty active there, but otherwise.
Okay, wonderful. I think that's a good answer. Okay, so I think on that note, we should bring the presentation to an end. Stef, thank you very much for joining us tonight. It was a particular pleasure for me to host this talk. And yes, on
thank you.
That note,
yes, great to be in at CIPIL again, although not live. It would be nicer to be in Cambridge, but
next time in person. Yes, exactly. So wonderful. Have a nice evening.
You too.
Bye.
Bye.